I'm going to call the meeting to order. First, I want to welcome Tim Ellenbrook, who's to my right. Tim's coming on board and is taking the place of David Sowers. And I'm very happy and pleased to have him. And I think you're going to do great. And the important thing, one of the important things, is that you bring an architecture background, which is what David had, David Sowers, whose seat you're taking. So I look forward to working with you, and I thank you for agreeing to serve. Most people don't do it, and it can be a pain in the neck and thankless, but I appreciate you. Yes, I know, I appreciate you coming on board. So,
but it's also really important.
Yeah,
the board does a lot of really good work.
Yeah. Well, we're glad to have you. So, the next thing is the minutes. We have, I think we have two sets of minutes, if I recall correctly. We have the, you can take the December 21st meeting minutes, and John, I think Kim went through and cleaned them up.
I think so.
Yep. I went through them, and I didn't see any mistakes or anything I wanted to change, but I open it up to the rest of the gang here. Are there any questions, concerns, corrections as to the December 21st, 2016 meeting minutes?
Nope.
No. Dave?
Okay. I'm sorry, Scott, I was just noticing that the revised schedule is in our packet.
Oh, good. Okay.
That's the one I created. I didn't know, John, if you have another.
No, I don't, but this one looks fine.
Okay,
Great,
so I'll
thanks,
just
Chris.
remove the February date.
Yeah, okay.
Yep. Anyway, not hearing any questions, corrections, concerns on the December 21st meeting minutes? No? Okay, I'll make a motion to accept them. Do I have a second?
Second.
All in favor? Aye. Opposed? All right, passed. And then next, we have the meeting minutes for January 4th, 2017. And again, I think they were reviewed by Kim.
Those weren't.
They were not? Okay.
January 4th, no.
Is there only one page?
Yeah, it was a short meeting. There's actually two pages. The,
at the back.
second page is just, it talks about Dowden.
Yep.
Which has now been withdrawn.
Correct. All right, there wasn't really much to talk about at the January 4th meeting, so that's why the minutes are so brief. I did not see anything that caused me any concern. I didn't see any mistakes. And but as to the rest of the board, does anybody have any questions, concerns, corrections, anything like that?
You might just want, it says due to Dave Tobias recusing himself, you might just want to say why. Seems always good to know why.
Okay.
And that's because,
Coworker?
yeah, one of my colleagues at the office is representing Mr. Gregory.
Okay, Chris, do you see that on under Gregory?
Yes.
About midway down, maybe say,
Common employer.
or you just say Dave Tobias recused himself because the applicant's representative is a coworker. Any other corrections, concerns? All right. Then I'll make a motion to accept the meeting minutes for January 4th, 2017 with that change. Do I have a second?
Second.
Okay, all in favor?
Okay.
Aye. Anybody opposed?
I'm going to abstain because I wasn't here at the meeting.
I should abstain because I wasn't a member of the board.
Right.
Okay, great. So we have 3, which is just enough. 3 yeses?
That's close.
Yes?
Yeah, aye. Yes.
Aye, aye, okay. So that passes. All right, well, next is the, we'll move along here, is the revised zoning board meeting schedule. And Chris, I guess you provided us with a...
Yes, this is the one that I did from the last meeting that we had. So
Right.
I wasn't sure if we were going to start in February or March, but I kept February on there, so I'll remove the February 1st.
Yeah, I think that's the way to go.
And then February 15th.
Yeah, maybe we can have some discussion about it. I talked with John yesterday about it. We seem to be in a lull, which is nice, after a very active fall. And as I understand from Art Broad and from other folks, most zoning boards meet once a month. That's the norm. Meeting twice is not. And since our load right now is fairly light, I thought it was probably a good time to try the transition. That doesn't mean that, you know, if we get overloaded, we can't schedule another meeting, but at least, you know, try to adhere to this. John, do you have any comments?
A couple of comments. I agree that monthly meetings are quite common. One of the other things that we're trying to accomplish with changing the schedule is to improve the quality of life of the board members by sort of having an impact on the pace of how everything proceeds rather than having the pace be dictated to us by the schedule. One of the important additions that we're adding to the board's policy is closing the agenda several weeks before the meeting. So it's going to give board members and your consultants an opportunity to have a couple of weeks to get ready for the meeting, which is something that's going to be a nice change. You can't have that kind of lead time if you're meeting bi-monthly. So I think I'm very, very in favor of the change. I think it's going to make it easier for you guys to do your jobs and give you the opportunity to do them even better. So I'm a big supporter of the idea.
Yeah, and so am I. And getting back to John's point, you know, Chris and Ron, it's a very difficult frenzy downstairs with the current meeting schedule we have, because you know they get these applications right before our meetings and have to really run. So I agree, John, that if there's, I think it's what, a 14-day lead time
Yes.
we're proposing. That'll give Chris and Ron plenty of time to process the applications, get the applications either to you or our Broad to review, and we'll have a chance to digest them before we get here. So I'm in favor of that as well. So any other discussion or thoughts about changing the meeting schedule?
I will not be able to make the March 15th meeting. I don't know if that matters. If you want to adjust it, probably don't.
Yeah, it's going to happen where people can't make a meeting, so I appreciate you telling me that. And, but I don't think it makes a difference as far as the schedule. So anyway, at this time I'd make...
Can I say something else
Sure.
too? You may drop off of your radar since you've been working bi-monthly, but you always have the opportunity to call a special meeting.
Right.
If the circumstances require that, to be able to come together outside of the confines of the schedule.
Right.
And we are canceling the February 1st.
Well, that's my proposal, is that we would start in February, and there'd be one meeting in February going forward, and then that would be February 15th, and we have March 15th, et cetera, as set forth on the amended schedule that Chris provided.
Always the third Wednesday of the,
Always the third Wednesday.
and it's nice and easy if the agenda closing is the first Wednesday,
Right.
14 days.
Yeah, but we have plenty of time to look at it, so.
Yeah, okay.
I think it makes a lot of sense. So anyway, with that said, I'll make a motion that we adopt the amended zoning board meeting schedule as proposed and as provided to us by Chris. Do I have a second?
Second.
Okay, all in favor? Aye. Opposed? All right. So that's the new schedule. Chris, you'll take care of posting that. Okay, great. All right,
So
next.
Chris, you're going to get it on the get it on the website.
Yes,
Yeah.
we'll
Okay,
do it
that'd be
tomorrow.
great. Super.
Yeah,
Thank you for this. This is
Well,
really
you're very
terrific.
welcome. There's just a couple of changes that I see, like the first and third Wednesday of the month of January and February, I'll remove, of course, February at 7:30. Now, John, do you think that at the bottom, the submission deadline is 14 days prior to the meeting at 3 p.m.? Do you think I need to mention anything about January being 9 days,
No.
right?
No.
It's just not needed. Should I remove the first and third Wednesday for January, that first line, or leave it?
Oh, you can leave it.
Leave it?
It lets people,
Kind
you
of
know, gives them something to refer to.
not get confused. All right.
Yeah, then you say third Wednesday of the month in February through December.
Yes, yep, exactly.
All right, great. And the next matter that we have no new applications, correct, Chris?
No, not at this
Okay.
time.
And as far as public hearings go, the first matter that's on is the Gregory case. And the planning board has weighed in on the Gregory case on a letter dated January 10th, 2017. They don't have any concern. I don't, John, do you know if Dutchess County Planning's time has expired? Yeah.
County planning did respond.
Oh, did they? Okay.
I think that's attached to, might be underneath the letter
Oh,
from the
okay.
planning board. And they responded that it was exempt. We sent it down in an abundance of caution because of Route 308.
Right. Okay, I think, all the referrals are back at this
All
point.
the referrals are back. Mr. Young indicated at the last meeting that he wasn't going to be able to attend. So tonight, you just need to make a motion to close the public hearing and then, have your deliberations and assign someone to prepare
Right,
a
and
decision.
that's what I was going to ask you. I think at this time it's right for a motion to close the public hearing.
I agree.
All right, and I'll make that motion that we close the public hearing in the Michael Gregory case. Do I have a second?
Second.
All right, all in favor?
Aye.
Aye.
Abstain.
Dave abstains. Everybody else is in favor. And John, do you want to entertain discussion now since we have a little bit of time before Ruby, which is the next one?
Say that again, I'm
Do
sorry.
you want to, shall we entertain discussion on the
Yeah, sure.
Gregory case?
Yep,
And that, to me, I think it's a pretty easy one. I don't have a problem with granting the requested variances. As I recollect, if we're calling it correctly, there were 3 originally.
Yeah, I
And
think it turned out that,
there's really only 2 because I think one's grandfathered.
yeah,
That
the
is
minimum parcel size was not necessary.
Right, so it's just the 2.
So you're looking for rear yard setback and side yard setback.
Right. I don't have any problem with the application of granting the 2 variances that are still required, but I'd like to hear from the rest of the board as to your thoughts. If any.
Yeah, I don't think there's an issue.
No, I don't, it's fine.
But it's just, these are pre-existing with the existing structures, so it's matching.
But
So one of the things I'd like to start moving to going forward is making sure that when you have your deliberations that you go through the criteria that's set forth in the zoning law for an area variance. And if you look at if you guys have the template handy, I don't know.
yeah, I do. I guess we'd be going back to, is it page 4 for the most part, considering the 5 factors of balancing?
Yep. And when you're having your discussions, my suggestion is that it would be good to go through those factors not only for the, not only does your decision have to incorporate those factors, but also for the benefit of the person that is going to be assigned to write the decision, so that they know what the board's
Right.
feeling is with respect to each of those factors.
Okay, does,
Tim, do you have the template? You might not have.
I was just handing a copy of
You have a copy?
the template for resolutions.
yes.
Yes, yep.
And we're basically talking about paragraph 14.
And
Yep.
Scott, I'm sorry, I think that suggests that we assign the person to write it up before we start the discussion instead of after, as I think we usually did.
Well, I don't care. We can do it before or
I'm
after.
saying
I'll volunteer to
as a-
do it.
No, I'm just saying as a routine, as a routine
So that
process.
person
can take notes.
Yeah. Okay, it'll be me. I'll take a first stab at
Okay.
using the new template.
Yeah, it'll be a dual purpose, and you can test drive it and see how it goes. When it's used from scratch, it should be even less trouble though, Scott, because all the factual information in the beginning should be filled in. If you take this up when a new application comes in, then the decision, the factual parts of the decision should be already written by the time you actually sit down to do the substance, but anyway.
Would the minutes have who the representative was? Let's see.
Yes, it should.
Okay.
And it's actually on the application.
Okay.
Was that template distributed last meeting?
I don't know if it was.
I got it online.
Yeah, I got it online
John
too.
sent it around by email.
Yeah.
And
I have a copy here, Jeff.
that's okay. Yeah,
But,
We're talking about paragraph 14.
Scott, months ago, we had the application, or we had a letter from the zoning officer. We don't have that now, which is fine. In other words,
You mean
if I
the
was
denial
drawing this
letter?
up, yeah.
We should have that, that should be,
Do we have a letter?
yeah.
Okay. Actually, I have that.
Yeah, we.
All right, the application we do have, right, okay. All right, so everything that we need is in there, okay.
Yeah, all right, so do you want to go through the various criteria? It says A, 14A, if the variances are granted, will they cause an undesirable change in the character of the neighborhood or cause a detriment to the nearby properties? Based upon the plans that, I've seen, it's a pretty modest proposal, and I just don't see that this addition is going to materially change or affect the neighborhood. That's my thought. Anybody? Any other?
Yeah, I agree with you.
And this is not etched in stone. I mean, when I bring the resolution in February, if there's some changes you want, or if you feel differently, you can just let me know.
Also, another factor with regard to this is the fact that the public hearing was held. I don't believe anybody from the neighborhood came forward to express any concerns
No one
about
did.
this.
Yeah, and we usually note that, so.
When was the public hearing open for this? Last meeting?
I mean, this may have been opened in the last meeting in December.
I think you're right. I think it was the 21st, and then it was held over, waiting for the referrals to come back on the 4th, and now we have it on tonight. Okay, any other thoughts on 14A? Because then we can go to 14B. Can the benefits sought by the applicant be achieved by some method feasible for the appellant to pursue other than the area variance? I don't see how it could. Are they getting at changing it as far as putting it somewhere else on the property, or?
That would be one of the reasons if we thought it would be elsewhere. You might want to fall back on the application for the explanation as to why that particular site was was selected.
Yeah, most of the time, I think we usually use that for, when we have freestanding garages and other things, and there's a big piece of property, and we asked if they could put it somewhere else. So, but this is, proposed addition is right next to the existing garage, according to the plans. Okay, is the requested variance substantial? Again, I don't see that given the size of the property. It's, even though it's substandard, it's still 3.3 acres. And just the proposed addition is 24 by 22 by 20 and a half feet. So, given the size of the property, I don't think that applies either.
Well, substantial, and also you have to bear in mind when you're, so what the cases say is that substantial can sometimes, it's appropriate to consider what's substantial simply as a function of the arithmetic in terms of, so here, you've got a 50-foot setback that's required for the rear yard, and the variance that's sought is 31 feet. Numerically, that may be substantial, but the courts also say that with regard to substantiality, you also can look at the surrounding circumstances, and if the rest of the lot is big and no other neighbors are close, then even though those numbers appear substantial in terms of the impact, it's not substantial. So that's just a little bit of guidance in terms of how to think about it.
Okay. Will the proposed variances have an adverse impact on physical or environmental conditions in the neighborhood or district?
We think not.
Yeah, I would think not. I mean, it's just the small addition. And is the alleged difficulty self-created?
And then the answer to this question is yes, because the zoning law has the setback established. This request for a variance came to light after that was established. Residents of the town are presumed by the law to be on notice as to what the setback requirements are. So is this so this is self-created, but what the law also says is that while if it's self-created, that's a factor to consider, but that's not dispositive.
Right.
As compared to if you've ever heard in discussions with use variances, if the hardship is self-created, that's fatal to the application.
What was the word you used, dispositive?
No, it's lawyer talk, you know? Yeah.
You wouldn't understand, you're an engineer.
I know. Can you translate that into another form of English?
I'll be happy for
Yeah, we
next
can
meeting.
later we can have a beer and throw around
It's
incomprehensible
not
terms.
dispositive, I mean, it's not decisive.
It doesn't
It
decide
decides,
the
yeah.
issue, yeah. Because what you have, and just to go back to remind you, that is, what you're doing is you're conducting a balancing test about whether if these variances are, is the benefit to the applicant outweighed by the detriment to the community by granting the variance, and the law requires that you consider these 5 factors. So those are considerations that you put into a basket, and then you do the overall balancing and come out with your decision.
Okay, so I'll try to add some meat to the various paragraphs. When I talk about paragraph B, I will be using the word dispositive somewhere in there for your benefit.
Thanks for the education.
Not a problem. All right, John, anything else, or anything else we have to do under with this new template as far as consideration of where we're going?
No.
Okay. All right, so I'll write that up in the affirmative and have that ready for the February 15th meeting. Yes. We're catching on. All right. It's 8 o'clock, so John, do you want to talk about the Rugi application?
Yeah. Do you want to open the public hearing and then
Sure.
continue it, since at 8 o'clock, that's what we're supposed to be doing, and then I'll
Right.
follow up and explain to you what we're up to.
All right, well, since it's 8 o'clock, I'll open up the public hearing on the Rugi matter, and John, you can give us a thumbnail or as big an explanation as you want on
Yep.
what's transpired since the last meeting.
Yes. So do you want to see if there's anyone here for the public hearing, or do you want me to?
Yeah, you know, I know there is one person here. Is there anybody here for the Rugi matter? Sir?
I'm here for Rugi, but the thing is, our lawyer called me and said that he talked with Marvin, and he's not here today, and I know you will present your memo, which I have a copy in the meantime as well, and
Okay.
so he said there will a continuation, and so I'm just here in case there's anything.
Can you give our clerk your name and your address? I know you have before, but just for
My
tonight.
name is Carl Landry, 35 Way Road.
Okay, John?
Okay. So I sent a memo around this evening. I don't know if there's anybody here that I printed out some if you want it, so that you wouldn't have to print it on your own. You have it around?
Unless there's a color copy.
Well, this is a color copy.
I'll take that.
So, you may recall at the last meeting, there was a dialogue that was had. John Marvin is a lawyer who's appearing for Rugies. Scott Volkman is appearing also for Mr. Lamprecht and also Ms. Putnam. And we had a discussion at the last meeting about the clarity of the issues as presented in Ron's determination. And the reason that that's an important issue is because I think it'll save Rugies, it'll save the neighbors, it'll save the town a lot of trouble if whatever issues that have to be addressed as part of this plan get addressed all at one time, so that this doesn't keep coming back piecemeal to the ZBA and costing everybody time and money. And Ron did a pretty good job of reciting a history to this, and the fact, that's why I attached his determination to the memo that I sent you. But what we really needed to figure out, this came into the town as an application by Rugies for site plan approval and for a special use permit. And they have 3 parcels of property up at the intersection of 9 and 9G where they have their Chrysler Jeep dealership. And they want to expand that they want to expand their operation. They want to take down 2 buildings on the parcel that we call the main parcel, which is the one that's right on the corner. And that's going to be replaced with 1 building that's a little bit smaller. And then on the annex parcel, which is where the car wash used to be, just to the north of that, on the same plot near the cemetery, they want to take down the building that's on there, and they want to put a much larger building up on, I think it's 2 buildings up on that piece. And they're also going to be expanding parking. And then they also have another parcel that's adjacent to the main parcel, which has a cottage on it, and that's why we call it the cottage parcel. And they want to expand some of the parking up to that parcel. Auto dealership use is not a permitted use in for any of these pieces of property. The main parcel is in the Crossroads Business Zoning District, and the annex parcel and the cottage parcel are in RC5, Rural Countryside 5, which is a residential district. And so the applicant has asserted that they have a non-conforming use on this property as it exists, and they want to expand the non-conforming use. Non-conforming uses are uses which are not allowed under the zoning law, but which have been established before the zoning regulation was put in place. And that can apply either to the initial enactment of the zoning law or to, as you might recall in the case of Red Wing, to changes to the zoning law that are enacted by amendment. And as a general matter, non-conforming uses cannot be expanded. The zoning and planning policy behind non-conforming uses is that, you know, the zoning law doesn't allow them. We're not going to, the law says we're going to respect the rights of those people who were engaged in those uses before the prohibition got enacted. But the overall policy for non-conforming uses is to see eventually that they get phased out. And that's why you often see in zoning laws that there is a sunset provision. If the non-conforming use is discontinued for a certain period of time, that the ability to conduct the use on that property terminates. So there's a general prohibition in our zoning law saying you can't expand non-conforming uses unless the manner of expansion is expressly allowed in the zoning law. And then there's a section of the zoning law which follows, which explains the conditions under which non-conforming uses can be expanded. And there's a percentage of expansion, 50%, which is set forth, and that sometimes can relate to floor area, and sometimes that can relate to site area. And there's also a paragraph in the zoning law that relates to the volume, expanding the volume of the non-conforming use. Sometimes you can, if you want to think of that as the intensity of the use, rather than necessarily making the building bigger or spreading out further on the site. So the Rugi's plan is what they want to do, which is expanding out onto these three parcels in different ways, is simple in concept, but it actually triggers a whole host of different issues under the zoning law in terms of whether this plan can do it and how does the zoning law apply to this plan. And so this is all a warm-up to the discussion that we had last week, where we wanted to be clear about what questions are being presented by the board. The object of the applicant is to come out of, their hope is to come out of the Zoning Board of Appeals with a decision, and if that decision allows, says that this plan can go forward under law as it's drafted, they want to be able to be clear to go through the ZEO and submit a plan to the planning board, and that's why we're trying to resolve all these issues. Now, of course, depending on what you decide, they may not be able to do that, because you may decide that the law, in the way that it applies to this application, isn't going to allow that to happen. It's premature at this point. I haven't formed any opinions with regard to whether that can happen, and it's premature for you guys to be forming opinions with regard to that. So what we're trying to do is to break this up and operate effectively piece by piece. And so the first thing I did, based on the conversation at the last meeting, was I said that I would look through the file, and I would frame the legal issues that are presented as part of this decision as best I could. I think I mentioned that if it was necessary, I would sit down with Ron. As it turns out, that wasn't really necessary. I think I was able to understand what issues are presented with an in-depth review of the documents. And you'll see with the memo that I sent to you that although the concept is simple, I've identified, I think, 9 different questions which are going to have to be resolved as part of this application. And so, I just laid this on you guys today, and same thing with the lawyers for Rugi and the lawyers for the neighbors. And I did express to them in the email today that the reason they're not here tonight is because, there was just no way they were going to be ready. I knew you guys weren't even going to be able to have read this memo by then. But for the next meeting, I think this memo will give you a good handle on the issues that are presented. And then I've indicated to both John Marvin and to Scott Bolton that if they have comments on these issues, that they should submit them in writing to the board. I suggested that they be submitted by February 1st. I think John Marvin's going to need a little bit of extra time. I also took the opportunity, I sent a copy of this memo on to Art Broad and Michael Trimble to just get the planning board view of this, just to make sure that everything is fitting together as we're going forward. Once the issues are understood by the board, ultimately this board will decide what the issue should be. We are bound as a board, you're bound, of course, you're an appellate body, so you have to respond to issues that are presented by the application, not necessarily pulling issues in of your own volition, okay? But I think that everything that's been unpacked here is something that's in the basic decision that's been issued by Ron in one way or another. And then you may need more fact information. if you just sort of think about how you went about your review in Red Wing, which was you were gathering both fact information and legal arguments at the same time with the goal of, after the public hearing is closed, and putting those things together. Using one example, to expand a non-conforming use, you need to be a non-conforming use first. And the applicant has the burden of establishing that they are a valid non-conforming use, and in this case, that has to be done with regard to 3 separate parcels, because those
So
3
when you're
parcels
saying that,
are-
John, they have to show that when they commenced those uses, they were valid.
Yes, that's
That
right.
the law has changed and made them non-conforming.
That's right, that's right. And because if they can't, if they're not valid non-conforming uses, obviously they can't be expanded. That's a fact question, okay? The applicant has the burden of
Could you
proof
repeat what you just said?
that the applicant needs to establish that they are a non-conforming use to begin with, that they began the use of the property before the prohibition in the zoning law.
And it was an allowed use at the time they started.
That's right, that's right. And Ron noted, for instance, as a question that the zoning in Rhinebeck was enacted, if my dates are a little off, this is in the determination, in the early 70s. And the use, according to his determination, the use of the main parcel actually began a little bit after that, but there's no record in town hall of an approval that was issued for that. There's different ways of trying to, we can go back and get aerial photography from the county and things like that to be able to see when things happen at a certain time, but the point at this juncture is simply to just explain that that's a fact question that's going to have to be answered. The applicant is going to have the burden of proof, and there may be other fact elements that come into this. So after you have a chance to review the issues, some of the issues are purely legal. They're just making a determination about what the language in the zoning law means as it applies to the facts of this case. And I attached to the memo for you the excerpt from the zoning law that deals with non-conforming uses. It's not very long, and you can take a look at it and you'll begin to get a feel for the language that we'll be interpreting as we go forward. So,
Are there some seminal cases that you can refer us to on this issue? Just like, as in Red Wing, there were maybe like 6 cases that were really governed, the Red Wing case, and we plugged in the facts.
Yeah,
Is there something
yeah.
like that here where you could?
I think this case is going to be a little bit different because in the mining cases, the way that the mining industry has chosen to litigate has resulted in there being like half a dozen cases that really tell the whole story on the non-conforming use issue. Non-mining, non-conforming use issues are almost at the complete opposite end of the spectrum. There are thousands of cases on them. They often turn on the facts of a particular case, and so the precedential value is limited. To the extent that there is authority with regard to the various issues that are presented here, I'll try to help you out with that. I'm also hoping that the lawyers for the applicant and for the neighbors that have concerns about this will also present us with authority that will help advance the research on this.
So, John, just to clarify, I can think of at least 2 valid non-conforming use examples. One is that they had a use that didn't need approval before zoning was implemented.
Yep.
Or after zoning was implemented, they started a use that was approved, that was waived.
Yes, well,
They
let's
received
say,
the
let's use the annex parcel as an example, where they acquired that, and they did go before, there is a record that they went before the planning board, and they received site plan approval to use that for an auto dealer.
After zoning was implemented.
Yes.
Right.
Yep.
So are there other examples of valid non-conforming uses than those 2?
With regard to this project?
Well,
Or
any
just
project,
generally?
yeah. Well, that seems like that's it, isn't it? Either you started before
Right.
zoning, or you got approval.
Or you got approval and they changed the zoning underneath it. Those
Right.
are really the two
Okay.
most common circumstances.
So if zoning changed and then you started a use but didn't get approval for it, that's an invalid non-conforming use.
Right.
Okay.
John, correct me where I am incorrect. Did not Rhinebeck redo its master plan recently?
Yes, and so in 2009,
Yes.
we enacted a new zoning law and a new comprehensive plan.
And was each street, each area, Rhinecliff rezoned?
Yes.
Then why are they referring to 1917, 1971?
Well, that's because that's when zoning was first enacted in Rhinebeck. So any business or any use of property that was taking place prior to that date would be allowed to continue as a non-conforming use.
Wouldn't,
Right,
Sorry.
but did not Rhinebeck look at this intersection in 2009
Yes.
and decide this is going to be residential, commercial?
Yes, yep.
but it's effectively a grandfathered use, still, regardless of how zoning
Yeah.
Well, you
changes.
can't use grandfather, so in 2009, they redid the zoning law, that parcel on the corner, for instance, used to be in a zone that was called highway business. It got changed to crossroads business. And I don't remember what the previous zoning designation was for the annex and the cottage parcels. But after 2009, auto dealership wasn't allowed was not an allowed use on any of those parcels. So the use continues as a non-conforming use,
Thank you.
not subject to scrutiny prior to this time.
All right, and as I understand it, you've sent this memo to the attorneys and you've given them a briefing schedule.
Yep.
So probably the thing to do is just to make a motion to extend the
Continue the public hearing.
public hearing
for the
until
next meeting.
February 15th.
Yeah, I think we're gonna have to
Well,
extend the public hearing to a sufficient point. I've assured both Scott and John that they'll have everyone who has a concern about this will have a full and fair opportunity to be able to submit whatever information and arguments that they want to the board before a decision.
All right, any other questions, concerns?
Yeah, I'm sorry, so between now and then, could we be asking the applicant for information?
I think that the first step, I would suggest no for the moment. What I would say is if you are starting to have questions about information that you think you want to get, make notes of those and bring those notes with you to the next meeting. I think the first step, though, is to make sure that we have the questions, defined. And then once we have those questions defined, then we can go on to the issue of what facts are necessary in order to resolve those questions.
And I bet you that knowing both lawyers who are excellent lawyers, they're going to supply us with the facts to answer the 9 questions that you set forth. So we'll probably have a lot of that information. And we can ask them questions.
Yeah, and you've asked for information before. You're fact finders. It's perfectly fine to ask. They don't have to give it to you if they don't want to. As you learned in another application, sometimes you ask and you don't get it, but it's perfectly appropriate to request information.
Okay. Well then, I guess at this time I'll move to continue the public hearing until February 15th. Do I have a second?
Second.
Okay. All in favor? Aye. Opposed? All right, so it's over until the 15th, and sure I'll have more information. Bless you. Okay, the next case that's on is McNown. And just going through it, it looks like the planning board has responded. John, I'm not sure, I'm unclear whether Dutchess County responded. I know there was a referral out, but I gotta believe their time has probably elapsed if they haven't responded.
The Dutchess County planning referral was not required.
Okay. So it was just the planning board, and they said they didn't have any concerns, is that right? Correct?
Yep, CAB also responded
Okay.
that they had no concern. So you're in a position today to close the public hearing and begin your deliberations.
Right, and I know we have somebody here from McMahon. Would you like to state your name, and then if you want to say anything?
Do you want to say any drawings, or do you feel like you know that?
I think we know the application pretty well. It's been before us before, so.
Yes, I'm Jonathan Hoover. I'm representing Jonathan McCown, the owner of 664 River Road. I can run through. It's an 85-acre piece of land, and there's 3 buildings right now: the farm stand, the small farmhouse, and a garage. And we are proposing demolishing the garage, which is the town historian determines not historic, and then create a new garage that's set back further from the road. It's another 600 square foot garage. We're pushing it back as far as we can without disturbing the tree line. And then we'd also, adjacent to it, like to build a 600 square foot workshop. And we're asking for variances because it's a 200 foot setback, and I think we're asking for a 10 foot and a 59 foot variance. And then I know there's the issue of the generator before, which made a change now for relocating a generator, but I believe it doesn't apply.
It doesn't apply, it's not an accessory structure.
Yes.
And if I recall, I may be wrong, please correct me, this is the same application you presented 2 years ago that we actually granted the variance.
Yes, sorry, we didn't break ground in time, so it expired.
No changes?
No changes at all.
Okay. Any other questions of the applicant?
In my notes, we were also to notify Red Hook. I think that's on this. Is this property near Red Hook?
It's adjacent to Red Hook, so half the property's on Red Hook, half it's in Rhinebeck, but everything we're doing is in Rhinebeck.
It's an interesting question.
I think we said that we have to notify. I think I would
Yeah,
call
I
that
agree
to
with that.
Richard. Yeah.
I don't know the answer to that offhand.
How close is the nearest activity to the Red Hook border, roughly?
I think it's like 3,000 feet, 4,000 feet.
Hey,
I can tell you exactly.
Over half a mile.
What I would suggest is continuing the public hearing to the next meeting. You can begin having deliberations tonight based on the information that you have so far. You're going to assign someone to write the decision. We'll find out whether notice of the public hearing was supposed to go to Red Hook, and if so, we'll get that out in time for the next meeting. And then the public hearing can be closed at the next meeting, and then you can issue your
Do
decision.
the resolution as well.
Okay,
Okay.
good, John.
Did we sign this resolution?
If not, who wants to volunteer? I took one. Richard? Okay. So, all right, we'll continue the public hearing until February 15th, but as our council has suggested, we're going to start talking about it and where we're going with it, and we'll see if we need to make a referral over to Red Hook. We'll do that if we need to immediately, and be in a position hopefully to render a resolution, a decision on February 15th.
On that same.
Yep, so
Yeah,
no
same
time will be lost.
Okay, yeah, that was my question. Just how many more meetings it typically is, and then if you need me for all these.
No.
No?
Do you need me for the next one or no?
No.
You don't? Okay, great. I'm driving up from Brooklyn, so
Yeah.
I appreciate anything I can do remotely.
Unless we hear from Rhinebeck, or and there's going to be some kind of,
They'll have an opportunity to appear at the public hearing if they want to. I mean, I would not expect that there's going to be any interest about it.
I don't think they're going to care. It's not in their.
We just have to find out whether or not it's a requirement to notify them.
Okay. So, yeah, I would say no, you don't have to be here for that meeting. And we'll give them plenty of time, so either they'll respond or the time will have lapsed. Although February 15th, they'll probably, is it going to be a 30-day?
No, it's not. Don't confuse the notice with the referral.
Okay.
It's not a referral. It's just providing notice so that if there's someone at the town of Red Hook that has something to say about this application, that they would come to the public hearing and make a comment about it.
All right. Do you want to go through the various things we have to go through under paragraph 14 of the, we can talk about that now?
All right, if the variances are granted, will they cause an undesirable change in the character of the neighborhood or cause a detriment to nearby properties? My recollection is that there should not be any problem with the neighborhood or the neighbors. B, can the benefits sought by the appellant be achieved by some method feasible for an appellant other than an area variance? I don't think so. I don't think there's any other way of doing it. Is the requested area variance substantial? Two front yard requirements of 200 feet each proposed. Well, one is
Yeah, one setback variance is from 200 to 141.
one and one is to 190, which is not
It's not that substantial.
substantial at all.
And then there's also, is there also the maximum accessory structure aggregate size from 1,500 to 2,200?
Right.
So, I mean, and just the size of the property and where it is and everything else, I don't think there's any, it's not substantial, the variance is not substantial. Going to, well, I'll let you know.
Yeah, proposed variance have an adverse impact for physical environmental conditions, the neighborhood or district? I don't think so. And E, is the alleged difficulty self-created? Perhaps yes.
Yes.
Yep. I think it's always going to be yes.
Most times
Yeah.
it's going to be yes.
But again, outweighing it, I mean, this is a project that we actually granted 3 variances 2 years ago, and now we only need 2 because of the change in the law. I didn't have a problem with it then, I don't have a problem with it now, so that's just my
Just
feeling.
one last thing, site visit. If we don't do a site visit,
You just drop that out.
Just drop it out.
Because your site
I'm good.
visit's not
I'm
required.
Yeah, and I remember it, so we did it, I think we all did a site visit the last time around, it was on. I know I was out there. Yeah,
all right, good,
You can drive by and see it anyway.
for the most part, yeah.
very good,
All right, so I guess drafted in the affirmative.
good, I got
And,
it.
let's see how you do, and hopefully we will deal with the resolution, vote on the resolution on the 15th of February.
Okay.
So you'll have your answer.
I can check that. You can let me know if you need to.
If something crazy happens, we will let you know, but at this time, I don't foresee any issue.
If I can ask one more question. With the,
Yes.
simultaneously doing the planning board, and I had my meeting last week, but then they realized they needed more information from you, so they're postponing me to the 4th of February. Will they be, I guess you
won't
communicate, do I?
Yeah, you will have it by then.
They won't have that, okay.
What information are they expecting from the board?
I'm actually not sure, because they told me to come last week, and then they said, oh, they need something from you for this is my second meeting with them. So they're gonna have a report that they said it needs to be there for that one.
Yeah. Okay.
Okay, well, I'll check with them.
Yeah, check with them. They can always reach out to, you can tell them that they can reach out to the lawyer for the ZBA to see if it's possible for us to coordinate. The thing is that with the possibility that someone from Red Hook could come in, however minuscule, I'm not sure that it's appropriate for us to be giving the planning board an assurance that the variance is going to be granted, even though
Understood.
that looks like what, very much what's going to happen. But if they have any questions, they can call me.
Thank you very much for your time.
Thank you, John.
Thank you. All right. Actually, I'll borrow yours. Do you have the, somehow I didn't know the papers I managed to misplace. Okay, great. All right, so McDown's done. Dowden has been withdrawn. So I think that's all we have for this evening.
So we have, I wanted to take 60 seconds to update you on the template. So we took the template and the referral guidelines and we sent that out to Art to see whether he would have any comments. He did have a few little comments here and there. So we're going to do a revised draft of the template and the referral guidelines and finalize them. The other thing that occurred to me tonight is I'm going to actually write right into the template what the balancing test is, so you guys will have it right in front of you. And then we'll issue your sort of final version of the template and the referral guidelines.
Do you want to see, since this is the first time we're doing it, would you like to see a draft of the resolutions?
Yeah,
Can't hurt.
yeah. And then the other issue was, there was talk about having Art come to your meetings for a few meetings. You wanted to go ahead with that, or?
I don't much care. I just appreciate and want to have it continue some help, either Art or yourself. I have no problem continuing with you. And I think it does make sense. I mean, I know Art deals with the planning board, so if he dealt with us, there'd be a continuity.
I think it might be worthwhile to have him attend a few meetings just so that you guys can begin, he can see what life is like for you guys and you can hear what he has to say about planning board matters that regard what business you're doing.
But on the other hand, he's not the lawyer, so especially on things where we need a legal interpretation or issues need to be phrased or set forth. I think we're going to need you.
Yep. Yeah. Well, we can come to the meeting as well, just because he's here. The issue of, you're requesting escrow is another thing that, we sort of need to take on. Ruby's is a perfect example of an application that should have an escrow because it's going to require quite a bit of work for me to I already have 6 hours into it, getting these issues crunched and the file reviewed. And the test is that if the applicant is apt to get an economic benefit from the approval if it's granted, this is an example where obviously, they get a big economic benefit if they end up being able to do the project as they plan. So,
well, I think since I don't recall us ever doing it in the past, or at least in the last 13 years, we're going to need guidance.
Yeah.
And if that comes from you or comes from Art, we're going to need guidance as to what to ask for, which cases, and how much to ask for.
Okay.
And John, also I printed off the planning board escrow document. I don't know if you want to review it, if this would be the same for us, or if you want to make changes to it. I don't know if you
No,
that across the board?
I mean, I'll take a look at, can I hang on to this? But that's essentially with a little customization. This is an escrow agreement. So this is what, when people submit their application, they sign this and they're agreeing that they're going to fill the basket up to a certain point to, as part of the application. And that if they don't pay, their application doesn't get processed. There's a section in the zoning law which discusses the authority to collect this, and then, I don't know if I sent it to you guys already, but I already did a memo a couple of years ago about the ZBA's ability to charge escrows. I will recirculate that.
I know
it explains to you,
do
it's
it.
not long, but it explains to you the circumstances under which you can have your expenses reimbursed.
But then again, we do need some kind of parameters.
Yeah.
And how does it occur at the planning board level?
Well, they make an estimate of, you know, the way that it usually gets done is you make a reasonable estimate. Let's say what happens elsewhere is that an application comes in, a copy of the application is sent to the consultants. So, sometimes there's a standing amount, like all right, we're always going to ask for 2 hours worth of consultant time, $300 from everybody. If there's a project that's much bigger, they may send the application out to the consultants, take a look at the application, tell us what you think your piece of this is, how, you know, what it's going to cost. And then a decision is based on the answers to those questions. And the board makes its best estimate, collects the money, it gets deposited with the town. If that money doesn't get used, the balance gets returned to the applicant. If more is required, then they go back and ask for more.
But does that process occur at a meeting, or is it done, you know, outside the meeting downstairs when the application is first filed, or sometime after that?
Well, the escrow agreement has to be, my understanding of what happens at the planning board is that the escrow agreement has to be signed at the time that the application is put in, just like they have to put in the affidavit of owner. And that the planning board makes a decision when the application is accepted as complete as to what the amount of the escrow deposit is going to be.
And you accept it, and then you get a check. What's the process after that? They come back the next day?
They have to send a check in, and, you know, then, you know, you begin to work against that. You have to do something that, you know, the consultants have to get their bills in on a fairly timely basis.
But the application is not, even it's accepted, but it's not processed, so to speak, until Mr. Green shows up?
I believe that that's the case of the planning board. I mean, when you got to remember, when you're for the planning board, when they're talking about hiring an engineer, hiring a lawyer, hiring maybe a biologist or something, all, you know, to provide advice on the project, you know, it's not unfair to require that assistance.
I'm not suggesting, it's just, it's new to us, so that's
Yep.
one I can understand how it happens.
Does the planning board use an engineer all the time, at their meeting, at every meeting, do they have an engineer?
I don't know whether Ray goes to every meeting. My experience has been different. I have boards where I'm representing the planning board, and they want me to be there at every meeting. Rhinebeck does not require me. They have a pretty highly skilled board, and they have Art providing them with
Right.
some help, and so I only go to a meeting when they ask me to go to a meeting.
Who's the engineer?
Ray Jurkowski from Morris Associates.
Yeah, when I was on the planning board in Tuxedo, New York, and the engineer and the attorney was at every meeting, and they were very active at those meetings.
Yeah,
At every
yeah.
meeting.
Yep. It depends on the volume that's being processed. I mean, there are places, Town of New Paltz, both the lawyer and the engineer are there at every meeting, but that's all getting charged through too.
Yes. Well, I would think we begin to respond to the request that has been made. Maybe we could just do it on a case-by-case basis, for example, like we, to just get it started, but we need some guidelines.
Yep, yeah. Well, I think what I'm going to do is I'm going to ask Art about attending a couple of your meetings.
Okay.
And I can attend also, and we can have that discussion. Because he's with them every meeting, he'll be able to give you an insight into exactly how the escrow is working, and how they do that over at the planning board.
Great.
Any other issues?
I don't think so.
All right. Motion to adjourn?
Second.
All in favor? Aye.
Aye.
Opposed? All right, we're done.
John, we rookie now.